right. I don't know how to refer to this interview. This isn't really a professor's record. This is a bunch of concerned patriots that have reached out to me, and through divine providence, I happen to see the right email at the right time. And but the question that was asked was about this thing called quo warranto. And I've actually heard this phrase several times over the past few months. And so I check on Wikipedia. I look at all the sources that everyone looks at. And you start to see things like, it started in England. This was something that we saw with the English common law. I'm trying to look for cases on whether there's any precedents. And my first observation is I've never seen it used, or if there's a case, it probably goes back 60 years. So didn't really think much of it again, but the question keeps coming up. And wouldn't you know, gentleman by the name of Stuart, who's on the line here, we've got Brandon, we've got Jenny, we've got some flies on the wall that are just taking out notes because they're also curious about what quo warranto is. So we figured we'd have a roundtable, talk about it, and perhaps we could share this video out and people can do with it as they will. Perhaps it'll answer some of their questions, and we can all make a better judgment on how we want to proceed in dealing with a myriad of concerns over election irregularities, election fraud. Many of us believe that there are certain people that are occupying offices, whether it's the president of the United States or in local elections, that simply don't belong there. So that's the broader vision for whatever time we spend today. But would everyone just go ahead and introduce themselves to whatever audience this video reaches?
All right, I'll start. Sorry. Virginia Sugarin, I'm an attorney in Washington State.
I'm Brandon McHouston. I'm a chiropractor in Washington State.
I'm Stuart Quint. I'm a Washington fly on the wall.
Okay. And we have some other folks like Pablo Martinez. He's also in New Mexico. We're neighbors, but we're separated probably by about a 5-hour drive. Big state.
Yeah, at least, yeah.
Yeah, and then we've got Samantha and Rihanna and Helen that are also here. And if they have questions, we'll certainly open it up to them. So what I propose to do is just tell you a little bit about the historical framework of quo warranto, where it came from. And then Jenny is going to chime in with her thoughts on why it's so important to what's going on in Washington. And I imagine many people that are watching this are going to try to think about, well, what relevance does this have perhaps in my own state? So what you need to know about quo warranto, it's a special form of legal action that's used to resolve a dispute over whether a specific person has the legal right to hold the public office that he or she occupies. Quo warranto is used to test a person's legal right to hold an office, not to evaluate the person's performance in the office. So this is different than what you would see with, say, recall elections or with impeachment proceedings where there was misconduct. Then you have some form of due process before you remove them. It asks a very different question. For example, a quo warranto action may be brought to determine whether a public official satisfies a requirement that he or she resides in the district, county, or whether a public official is serving in two incompatible offices. Now, what's kind of interesting here is we've been following the presidential election, and one question that needs to be raised is, what effect does fraud have where you weren't legitimately elected to the office that you hold? Because a lot of people ask me, well, if we can prove fraud, what does that mean? Well, a lot of attorneys know the old maxim of fraud vitiates all. Basically, it destroys a contract, because you can't have a contract if you didn't have a proper meeting of the minds. I think we lost someone. Let's bring them back in. So fraud is powerful. So thinking about fraud in the context of pro warranto, you can basically ask this perfectly germane question about whether President Biden has the legal right to hold his office. So this is extremely relevant. Quo warranto originated in English common law as a process initiated by the Crown to find out whether a person was legitimately exercising a privilege or office granted by the Crown, or whether the person was instead intruding into a royal prerogative. So a lot of, in the old days, you had to make sure you had certain claims to lands, titles, and this was a way for people to figure out who was who, and whether they were serving the interests of the Crown, whether these people were legitimate. So we historically thought about this as a more local issue. What's weird about this is we might be talking about the highest office in the United States, and we might be seeking to answer the question of whether quo warranto could be applied to a presidential race, which is, there is no, I can tell you this, having not read all the cases, I know there's no case on point with respect to that question. So that's a basic background. Jenny, why don't you let us know why you started getting interested with this topic, and maybe tell us the relevance to what's going on in Washington.
Okay. Well, a group of us in Washington State have been listening to Tor Says shows, and she was the one who started to talk about quo warranto. So I researched it, and as did a whole bunch of other people in a lot of different states. And what we are finding is that it appears that the November 3rd, 2020 election was held illegally in violation of the Help America Vote Act of 2002 and state statutes and state administrative code. And the basis for the concern is that the voting election systems used throughout Washington State were not legally certified at the time of the election. And they weren't legally certified because the federal oversight was lax, and the laboratories that are supposed to certify the systems were not accredited by the Election Assistance Commission at the time of certification, sorry. So that the both the federal and the state certifications are invalid, is our position. So the question is whether or not we can use quo warranto to challenge the election outcome, to challenge the actual office holders' positions because they weren't legally elected. And we've been looking at that, and it looks like, I know Stuart and Brandon, if you guys want to say anything, please chime in. They have looked at the various races across Washington State, and they found that 98% of our state legislative races were impacted by this, which means theoretically we could pursue quo warranto to remove almost every single House and Senate legislator at this time. So our initial strategy was a three-pronged attack. We were considering first sending letters to the actual elected officials, telling them, laying out the basis for the lack of a legal election, asking them to step aside. When they fail to do that, then go to the next level, which perhaps we were thinking might be our Attorney General, because these are state positions, and ask the AG to initiate an information and quo warranto, as it's called, with the Washington State Supreme Court. And when he refuses to do that, then bring our own action before the state Supreme Court.
Let me stop you real quick on that, Jenny, because you brought up something that I might forget. Brandon, I know that you worked on a report along with Stuart and another gentleman by the name of Eric on evidence that you've compiled that calls into question the certification of voting machines. And I'm assuming these are the machines that Jenny's referring to. What voting machines do you all use in Washington?
We have one county that's using Dominion, so that's not a huge portion of our systems, but we have Hart InterCivic, ES&S, Clear Ballot, and I believe those make up the majority of our systems.
Okay, so here's the other thing that we need to just get out there to the people that are watching. Everyone is starting to put two and two together about Dominion being really bad. What they need to prepare themselves for is that these other machines are also compromised. I forget the name, but I know the Allied Strategy Operations Group did a report and an audit within Texas, which doesn't use Dominion as well. I think they use ES.
Yes,
Yes.
Yeah. Which one was that again?
it was ES&S.
ES&S. Yeah, that's the one.
Yeah.
And they were able to find the same level of manipulation. Now I've talked with white hat hacker Joshua Merritt on some of the other voting systems that you just mentioned, and we're finding out there's problems everywhere, not only from just the certification, but the moneyed interest that are tied to this. There's a lot of politicians and legislators that have financial stakes in these companies. And so I would invite folks, if you have time, it's about a 3-hour video with Joshua Merritt, but it starts to scratch the surface on some of the things that Brandon's mentioned. But I wanted to raise these machines because once you start putting the pieces together, you start to see that you've got a serious problem, even in the states that don't necessarily use Dominion everywhere. A lot of times people think it's the states. Dominion will usually enter into contract with particular counties. And so we can also get into the idea of game theory on why they're picking particular counties and particular states. Of consequence, nationally, the Dominion machines were basically used in every one of the counties that were at play with the dueling electors. And I don't think Washington was one of them, but their footprint is large and it's getting much bigger. But Brandon, go ahead and let us know what your thoughts are on what you found.
That's something to add also.
Yeah. Well, essentially, we found problems at the federal level, which Virginia already mentioned, with the EAC certifications, with the labs not being accredited to certify those machines. In Washington State, we also have problems from the standpoint that our Secretary of State also has to certify and make sure those machines are properly certified to be used. In a lot of cases, the certification provided, there's no signature on it. It looks like a Word document. There's no seal. Accordance to the Washington legislation, that's a required piece of each document, is to have a signed and sealed document by the Secretary of State. So a lot of those systems, from a federal level, there's problems, but there's also problems at a state level. We have, I believe, one machine that has no certification at all from EAC or the state. So there's problems all over the board, really. And another
What sparked
problem.
your interest, Brandon? How did you get involved in this?
I just kind of fell into this. I saw what happened with the election, and I knew something wasn't right. And I started doing research, and I found this group of patriots that was interested in the same thing, and we just started digging.
Well, if you had to give a word of advice or an action item list for people that aren't in your state, because you've already gotten the ball rolling.
Yeah.
What would you tell? Okay, this is where you need to look. I mean, maybe you don't know the exact databases, but these are the questions that you need to ask. These are some areas where you could probably find answers, because what Brandon's getting at, this is huge. The reason why it's huge, and I'll give you a much more accessible example. I used to prove or have to try drunk drivers. Everyone has seen the guy that's doing the test, and they've got the horizontal nystagmus test, and then they got their whole things. But they also have this thing called an intoxilyzer. It's a machine that will analyze your breath or blood alcohol content, depending on which machine that you use. In order to get that little result and have it admissible in a court of law, there's certain things that have to happen. Number one, that intoxilyzer 8000 has to be certified. It has to be certified often. There's got to be records that are meticulously kept. And if that doesn't happen, that evidence isn't coming in, which means you don't get to a conviction. It's impossible. So in a similar way, if you don't have your logbooks you don't have your chain of custody, you don't have your certifications, you can't certify these machines. How can you then get a result that this person belongs in office?
Mhm.
All right. So people are like, okay, I understand drunk driving. It's the same concept here as it pertains to these machines. If you can't certify them, we don't just move on.
Mhm.
So Brandon, give us maybe 2 or 3 steps for our patriots out there that want to replicate what you've done to get to the truth.
I'm going to let Stuart do this portion. He'll lay that out really well.
Okay.
So I just really quick, I would say, and by the way, if people are really interested, there's a way, we have a spreadsheet that could easily be customized for your state. So what you need basically to do is figure out your counties, figure out your legislative districts, because it's not just did a violation happen, but was it material? Was it enough to significantly impact elections in your state? We then went to what are the voting machines that were used in each of your counties? You then want to look at, you go to the EAC website and you look at do they have certification and what were the laboratories that actually certified these machines? And again, as Virginia mentioned before, a lot of our contention, though not all of it, is based on the fact that the laboratories themselves at the time of certification lacked federal accreditation according to federal law. But I'd also say, I think one of the things as we talk to other people is that you don't just want to limit yourself to, well, the laboratories, and their accreditation. We found, for example, even in the process of certain accreditations of the laboratories, that the very federal procedures laid out in the law were not consistently followed. They're lacking documentation, the signature is not right, the term of the accreditation certificate expired. So you want to be really, scrutinizing what's going on. And then as Brandon mentioned, also look at the state certification, because even if you don't have the federal side, you want to look at the state because, again, I remember my family, we had to go through a number of international procedures where you get into notary seals, apostilles. They have to be, you can't just have it signed. It has to be sealed. The date has to be valid. And we found out that there were a number of examples where you had problems in those areas. That's basically what we did.
Real quick too, Stuart, can you explain how different states have different levels?
Yeah, that's a really important point Brandon's bringing up. So from the federal law, without going into a lot of bloody detail, but you want to make sure that you understand where your state's located. So the HAVA law has simplistically four categories
Stop
of
right
where
there.
states fall in.
Just for those that don't speak HAVA. When we're referring to HAVA, what are we referring to?
We're talking the Help America Vote Act of 2002. It was enacted right after, if you remember, the hanging chads in Florida back in 2000. So this is supposedly to make voting in America easier, and it had a big emphasis on voting machines. Some of the problems you mentioned about Dominion and others that are causing problems today. So HAVA opened the door for a lot of that. But what Brandon's referring to is you've got so like what our state, Washington, for example, that's a category 4, which means strict adherence to EAC accreditation of the laboratories, VSTLs, certification machines. They're strict. You must have that. You'll have other states where I think California might be one, for example, where it's a lot looser. There are other states that are in between, and the manual put out by the EAC will tell you where your state is, and they'll actually give you the specific provisions in your state law that define that.
All right. So after I get done with this roundtable, any links, PDFs, any guides or anything that
Yep.
you've done, I'll try to drop them down in the description below, and that way people will be able to access them and tailor them, modify them, or perhaps even take them to patriotic legal counsel that might exist in their own states. We are a dying breed. So thank you, Jenny, for joining us. They are hard to find, but it's so important. Continue. I didn't mean to cut you off, but I want people to know that they can get this information.
No, that's really it, and happy to send some links afterward.
Yeah. Now let me turn it back to Jenny. Based on your research, did you do a kind of a survey level legal analysis of what's out there in different states, or did you focus your efforts on Washington with respect to whether or not quo warranto is something that we can pursue?
Good question. Most of my research was in Washington State. I
Why?
have gotten, The cases are old, as you mentioned, but it has been done in the state before. For example, like someone challenged a mayor who was apparently not residing in the district that he should have in order to be mayor. And in that case, the court said, well, great that you've brought this up, but you should have, the timing is not right. And, the court found all these excuses not to do what was absolutely obvious, which was he's not residing in the district. He's not eligible for office. He should be, removed from office. So it's been hard to find a case that would really support the situation. And so I've reached out to other states and I've asked for some precedent that would help us. An example being a case where maybe a prosecutor goes after a statewide position and gets that person removed. And I haven't gotten any word back from anyone.
Yeah, the case you're referring to that you researched with the judge, is that Brown versus Warnock?
I believe that was, yes.
Yeah,
Yes.
and so a lot of these cases, again, I think the legal theory is well tailored to the very questions that were raised, because the document that I was referring to earlier, just to kind of give everyone a primer of what Quo Warranto was basically a script that was provided by an attorney general out of California. And I know that of all the states, California is going to have probably the most lax interpretation. So if we can agree that there's a consensus out of California, likely you've got the same type of explanation in other states, loosely speaking. You also, and that case was from 1942. So that's what I meant by these are older cases.
Right.
I didn't find anything in New Mexico through a quick search. It wasn't exhaustive. And then there was another case that you sent me, Jenny, and I think that was,
Yeah, the Quick versus Rubin case. I think that was 1998.
yeah, a little more recent.
A little more recent, and I can't remember exactly. Sorry, you're going to have to be the professor here. I haven't
No,
read it in a while.
it's fine. There was a question here. The summary was that there was a losing candidate for election to the Superior Court brought a private quo warranto action asserting entitlement to the constitutional office as opposed to the election winner. The losing candidate claimed the victor was not qualified because the victor was allegedly not a county resident. So this goes back
Okay,
to
that must be the one.
certain
Yeah.
requirements, right?
Right.
Now, surprise, surprise, the court said, petitioner, we're not really going to get to the actual merits of the case. You lack standing. And if you lack standing, we really don't have to address the merits, right? It's a sword and the shield thing. So you've got a legal remedy. So they basically, I think, said they didn't have standing. There was another question raised about whether the action was brought prematurely. So you start getting into issues of mootness, which is kind of the counterpart of standing. Usually when I talk about the sword and the shield, it's if you bring it too early, you don't have a real injury, go away. If you don't have standing and you have a generalized harm, we're not going to acknowledge it. We're not going to look at the merits of the case. I think the Cliff Notes version is they didn't really get to the issue of whether quo warranto was appropriate. They really didn't comment on it at all because of the standing issue.
Right.
Is that what you recall?
Yeah, they just look for issues to kind of get it out of their courtroom. But there is a definite need in Washington State to have a special interest in the position that you're challenging. And the treatise that I read described it as, typically a failed candidate. So someone who lost in the election challenging the person who won. But, that's difficult in this situation because if the actual election was invalid, then the person who lost is no more a valid person to challenge than us or a concerned citizen. So the question is, if you really have an election that should be rendered null and void, who has standing to challenge that? And that's something we've been struggling with. Do we have standing? So, my initial draft to the Washington State Supreme Court says, hey, we're interested, concerned citizens, we're here. We are ready, able, and willing to step into these positions until a valid election can be held. I just don't see a court doing that. But, what would they do? What would the remedy be? you have to have somebody running the ship. So they could order emergency elections statewide, but then you'd have to get new systems in place before that happens. It's going to take time. We've talked about bringing in blockchain systems for secure voting, and that would take, a lot of time as well. So what do? Do we have to wait? And the more we wait, they'll come up, say, well, you've waited too long. You're barred under the doctrine of latches from bringing this because you knew this or should have known this in 2018. Because some of these companies weren't accredited starting in 2017 or even earlier. So they could say, well, you should have figured this out earlier and you didn't. So you're barred from, bringing an emergency action. I just don't know how we establish standing and what's the right timing, as you've mentioned. Those are two big issues.
Yeah, I think one of the things I suspect, I reference Judge Humatua's case out of Arizona on some of the bad behavior on behalf of the court on how they're kicking these cases out. That case in particular was Sidney Powell's, but they kind of telegraphed what they're going to do by virtue of telling you the remedy that you're asking is so beyond the pale that they're going to create the legal framework on why that's what they're doing. They're not concerned about following the black letter of the law. What they're telegraphing you is, do you realize what you're asking me to do? And that's not the way that a judge is supposed to work. The judge is supposed to apply the law, consequences be damned. That's why your figure of liberty, holding the scales of justice, is blindfolded. It's the same thing here, but they're not doing that. They're looking at all of the political calculus, all of the blowback that's going to come back, and they're going to create their legal framework to not get there. So the doctrine of standing, as I understand it, has been so undermined to the point that it's not even recognizable. And that's not, I'm not being hyperbolic. We're talking about the President of the United States, in one of his particular cases, was dismissed for standing. He's on every single ballot, and he was found. So most states, you'll have to be a statutorily legal elector, meaning that you've got some skin in the game as someone who voted. Lynn Wood, while he was not a candidate for office, he was someone that Georgia law would describe as someone who was duly authorized to basically assert a claim because he voted in that election and he was a recognized elector under the law. Some courts are saying that's not good enough. No standing. His case survived, but then later was denied under a writ of certiorari at the Supreme Court. So they didn't hear the case, even though it wasn't dismissed straight away on standing grounds. And so I say all this to tell you all that we're getting inconsistent rulings from judges on people that classically would have standing. The president normally would, just like George Bush and Al Gore had standing in their cases back in 2000, 2001. So we're seeing a constant evolution or moving of the goalposts to make it more difficult to get the heart of this. And the problem is this: once you believe that election fraud is pervasive, there is no outcome that we can describe that's not going to require a monumental remedy, if it's as pervasive as many of us think it is. So I think our problem isn't so much the legal analysis of what we're covering here or whether it's applicable. This gets back to judicial integrity. Who wants to take some shots for the patriotic team? And as of yet, I haven't found any judges that are willing to do that. We've got some judges that are giving us favorable rulings on small potato items, incremental little victories. So we've got some cases where they've been heard on the merits, and I've talked about those in previous podcasts. When you look at what was decided in those cases, though, they weren't dealing with the heart of the issue, which is just a great deal of corruption, not dealing with just voter fraud, but election fraud. There's a difference. Election fraud is systemic versus voter fraud, which is kind of your bad actor that's trying to work around the law in how they cast their vote. What other questions do you all have that you think would be helpful for our audience?
I have a interesting question in general. Given the situation of the judicial landscape that we're in, is there any merit or is there any purpose in filing an action that you know is going to be dismissed just for a couple press releases? I mean, we're up against this huge wall, and I just don't know what we do. Do we fall on our swords, or do we go back and find one red county, one judge where we might get a ruling of some sort and then try and build from there?
Yeah, I think that you fight with everything you've got wherever you can fight. If for no other reason that we're raising awareness of this remedy, and your average ordinary citizen isn't dumb. They actually have an abundance of common sense, which is not something that we're seeing in the legal profession. We've got legal precision on how to get cases out of courts that need to be heard. So I think what we have to do is tailor these arguments and these lawsuits to let the people know that we're fighting for them on every single front. Now, there might be more wise places to initiate these lawsuits depending on the makeup. I'm at the point now where I'm so jaded over red versus blue. I think you've got certain bad actors in both parties. They just like their power. So it's not about merit. I think this is about pursuing, well, it's about merit, and these cases have merit. So let me say that. The question that you're asking me isn't really about the merits of the case. It's about kind of our self-fulfilling prophecy that we're so jaded by the corruption that will we get the result that we think is appropriate? Based on what I've seen over the past 4 months, I think the answer to that's no, but that doesn't mean we don't make our record. That doesn't mean that we don't let people know what's going on. It doesn't mean that we can't call out certain judges and attorneys that are on the other side, applying pressure on them, whether it's through a newspaper, whether it's through alternative media sources, which are rapidly growing. And that might be what we have to do, because what I think we're trying to do, we're trying to be place markers or placeholders of truth. And so if Jenny in Washington files a lawsuit that's based in the law, black letter law, that should be acted upon, where justice should be pursued to restore faith in your elections in Washington, and a judge punts and they're a coward, there's not much you can do about that. But what would be really cool is if something that happened in another state, like Maricopa, Arizona, unveils a smoking gun over not just certifications of machines, but just widespread fraud on the paper itself. Now, you were the brave soul that, when there was no hope, filed that lawsuit. It's a placeholder. And everyone's looking at what happened there, and they're saying, well, why can't we do that in Washington now? Now everyone in Washington, and this is a legal term, is beginning to lose their shit, right? They're starting to get crazy. They're getting crazed. Are there some ballots that we can shred? Are there some dumpsters we can find? And that's kind of what we need to do, is we need to be vigilant on all fronts. But Jenny, yeah, I think right now things look hopeless. They look like a lost cause, but I think we do it anyway.
Okay, that's great. I'm glad to hear it, and I'm willing to do it. And, falling on your sword is a kind of honorable thing to do. It's
the only thing to do. We have to save the republic right now. And so let's file that paper. There is that, what expression is, justice delayed is justice denied. This is kind of a version of that, where I think ultimately we're not going to get what we want with these quo warranto filings, but it's very, very different reasons than anything that has to do with the black letter law. But, we just have to, I'm a person of faith. I just think we have to be persons of faith, and we just have to pray through this whole process that people are connecting the dots in the right way.
Okay. So you see no problem with starting small or starting large, or, you just saying go for it wherever we can.
Well, again, if this was 8 months ago, I'd give you a much more precise answer on how to tactically proceed. A lot of I guess the counsel I would give you would depend on your resources. You know,
Okay,
how large
yeah.
you go really depends on whether we've got people that want to pay attorneys for their time, whether
Yeah.
attorneys will do this pro bono, whether we can convert certain actions into class action work. I'm not a class action specialist, so I really can't comment on that. But the scale of it can become quite large. I did see that there's a class action lawsuit that's been initiated over the Dominion machines. Slightly different issue than Quo Warranto, but you know, your question dealt with scale.
Yeah, and part of it, the scale question is if we put all our eggs in one basket and file one action with the Supreme Court, which I know like Louisiana is looking at doing, that's one swing, you know, one swing and we're out. Whereas the other approach would be to go county-based and go towards the county prosecutors and have them, you know, request that they seek the Quo Warranto or file the Quo Warranto with the Supreme Court. Then we could file more actions. And so the question is whether or not if we bring 10 actions versus one action, if we have the resources for 10,
Yeah.
is that a better strategy?
Well, I think it's if you do, go for it. If you don't, then you have to work with what you've got. I think we all have the idea of what a perfect lawsuit would look like if you practice law and what you'd want, and the retainer involved in all those things. You know, but I'm being confronted with patriots that are filing pro se lawsuits all across the country, and I don't ever discourage them from doing that. I'm just like, keep it up, fight the fight, because you're exposing truth, even if it's imperfectly, even if you're stumbling through the court proceedings. I mean, there's a reason why people are doing and bringing proceedings that they would have never thought that they would be the ones that would have to bring them. It's because they're desperate, for the truth to get out. And so there is a little bit of desperation here where we're like, let's just try it. What do we have to lose? Because, you know, if you don't believe that the person that's occupying the White House belongs there, you know, what do we have to lose? So let me ask you about this question of jurisdiction, because you talked about under Washington state constitution, I know that your Supreme Court has original jurisdiction over Quo Warranto, mandamus, I think habeas corpus. So based on that, is it your understanding that this goes straight to the Supreme Court for a filing, or do you have to have it originate in like a county prosecution? Do you know?
That's a big question we have. I don't know. I think it would be safer to exhaust our remedies first by doing what I call a shot across the bow, where you ask the person to step aside and then go to the attorney general or the county level and ask them to do it. And when they don't do it, then I think technically, if you go to Supreme Court, you would ask for a writ of mandamus to compel the AG to do his job. But we have the problem where the AG was elected in the same election. So we could file Quo Warrantos against him and the governor, lieutenant governor, secretary of state, who are all elected, and create conflicts of interest so that they can't even be mandated to do the job that they should be doing.
Yeah.
And then we go to the Supreme Court and say, look, everybody's out. Everybody's out. You got to kick everybody out and start over.
I like the sound of that. I really do.
Okay.
If there wasn't there a case, I don't have it in front of me, but I'm drinking through a fire hose here. Someone filed a Quo Warranto action somewhere in the United States that the judge sealed. Do you all know what I'm referring to?
Yes. District of Columbia. It's been sealed.
Okay. Is there any knowledge on how or to whom that filing was filed? Was it directly with, was it through a district attorney? Was it through the AG, or is it right there in the court?
I believe it was a direct filing.
Okay.
The Quo Warranto was included towards the end of the pleading. There was a lot about the election fraud, but she also included the Quo Warranto at the end. And it sounds like she just went straight to the district court of, I'm not familiar with the courts of DC, but
Neither am I. Yeah, I
Yeah.
don't have that. So I was like a court in general.
yeah.
Any other thoughts, questions on kind of a roundtable discussion on Quo Warranto? Brandon, Stewart, anyone else?
I don't think so for me.
No,
Would
but
you
just
all
thank
be
you for your
okay?
time.
No, this is important. I'm so glad that y'all reached out to me. I'm learning a lot even right now. I've been looking over at some of these cases and the stuff that you've sent me. Do you want people to be able to get a hold of you all if they've got resources, or perhaps they've done their own work on quo warranto in other jurisdictions and they just happen to watch this video? Would you all be okay with me sharing that information?
Sure.
Yeah.
Okay, well, I'll wait for Stuart to perhaps send me an email with what you want shared, and that way we can
Okay.
keep things up above board. But if there's nothing else, this was our, oh, Pablo's got a question. Okay.
Yeah, it's kind of off what these guys are going after. As you know, New Mexico is one of 3 states that uses all Dominion through the whole state. And why is that? You know, what Georgia, obviously stuff's going on there, Nevada, and little New Mexico, and we're kind of forgotten as a state, as you know. And anywho, we looking for information on the machines. A lot of the stuff about accreditation, dates, and whatnot that were discussed before. Some of it is just impossible to find. We dug and dug and dug, and some of it was impossible to find. So we asked for some information. I can send it over to you, but they said they would respond by the 6th. And that has come and gone, and we have not gotten a response back yet.
Yeah,
What would be the next step of that?
sure. So Pablo raises a good question. I suspect that little states like New Mexico, Nevada, that are, one, don't have the urban population centers of other states, especially states that have historically leaned left. And so when Democrats control your legislatures, to give you an idea about New Mexico, the House has only been controlled in New Mexico once during an 80-year time frame by Republicans. And the Senate, I think it's always been controlled by Democrats. Every once in a while, we'll have a Republican governor, which is really odd. But for the most part, the framework that's in place makes this a perfect place if you're going to try to get machines in, test them, figure out how to work out your theories of how to exploit weaknesses. Do it in a place that's apathetic, where no one's watching. And I hate to say this, but New Mexico is referred to as the land of mañana. We're late to everything. We're late to complain. That's actually helped protect me at my job. I mean, university, the one of the blessings from getting all these arrows is that even my protesters and detractors are too lazy to really do a good job of going after me.
I call us the petri dish of the left. It's like the executive orders today with the red flag laws. Where were they introduced first? Here and West Virginia. And it's all these ridiculous laws they push through unchecked. They end up spreading across all over the country. So,
well, not only that, you've got this problem with the amount of money. Now, Forbes did a report that New Mexico was the 2nd largest recipient of money to get Dominion machines in, behind New York. We actually requested the invoices. I don't think that's true. I think that was a bad calculation, but regardless, we still received a lot of money. So your second question, Pablo, is the equivalent of a FOIA or IPA request to get public information. And what I can tell you is that my wife has been on this. She's requested everything related to Dominion. We did get the invoices, and we're able to learn quite a bit about where the money's gone, what it's been spent on. Certain items like Dominion War Room. Why the hell would you have a war room unless there's some type of crisis situation to cover up, some issue where they're about to get exploited? They would not produce, or we haven't gotten the Dominion contract. We've requested that, I think, twice. However, I've found and received copies of Dominion contracts that were received in other states. I want to say it was DuPain County. I might be wrong on that, but I've reviewed it, and having audited contracts over my career, Usually these contracts are standard. They're going to be the same in every jurisdiction. There are provisions in those Dominion contracts that are telling the county clerks, if you want to do business with us, do not disclose anything. In fact, we're going to place on you a contractual duty to litigate and not provide any information about us. And in fact, there's provisions where Dominion will agree to pay the legal bills. Now, for people that are attorneys, that's rare, where you're basically volunteering that you yourself will indemnify or basically cover the legal costs to ensure that there's secrecy. Usually what you'll do is you'll say, if you screw up and you don't abide by the contractual terms, you're on the hook for the attorney fees. So that's the framework that we're working with. But the invoices will tell you a lot about your particular state. In New Mexico, we learned through the invoices that we have four terminals. Dominion's used in all 33 counties. So how in the world can you run elections in 33 counties with 4 terminals, especially when you've got someone like John Paulo saying that these machines don't hook up to the internet? Well, how do they communicate to one another to get election night results? It's a big fat lie. So perhaps just through the process of elimination, low-hanging fruit, for people that are watching this video, do a public records request either through your county clerk or your Secretary of State. Our county clerks are much more receptive to our requests than the Secretary of State. The Secretary of State won't give us anything, nothing. We've asked for information with respect to how they're cleaning up the voter rolls. One of the things that comes up quite a bit is we've got a population where I live about 250,000. So if you just look at natural mortality rates, 1% of the population is going to join their ancestors. So you expect that, probably 1,000 folks should be removed from the voter rolls. What we're finding is systematically only half of that amount are removed. I'm curious about whether or not those are Republicans being cleared and then the Democrats are left on. And the reason why that's significant is that if you know that you have a home waiting there for a voter file that's not going to go to the vote and say, oh, someone voted for me. Well, they know they're dead. So I suspect, this is just my working theory, that a lot of these states know exactly where they can find a home for filling out ballots and votes on behalf of the deceased. And we found that. And I'm still working on that theory, but Dominion and the Secretary of State is making that very difficult for me to learn. Any other thoughts or questions?
This is Rayanna. I have a quick one if you have a second.
Go for it.
All right. So my question is back to the Quo Warranto with regards to fault finding and it being a civil writ, meaning that the evidence that we in Washington have are pretty similar with regards to HAVA and EAC. And that then, as I look at it, puts the fault in the hands of shenanigans or lack of oversight in committees that are at the federal level. And then the Secretary of State's not overseeing that correctly. So federal legislation was not followed. So that's who's at fault for the elections not being correct. And it's not the office holders.
Mm.
So I don't know how important that is that we don't have our office holders that we're challenging be at fault. Does that make sense? And how that works?
It makes perfect sense. And I think this is what Jenny raised was, the remedy that we're asking is basically, in theory, if the certification has poisoned the election tree, everyone that's tied to that tree is basically poisonous fruit, which means we can call into question the legitimacy of anyone that was elected. And that's why this is just so, it's going to be such a tough pill to swallow for any judge to render a ruling, because we have to start seeing with our eyes open. And if you believe that the election was stolen through these machines, it's going to take sweeping reform. So you've got people that aren't going to want to be your standard bearers as litigants, as plaintiffs, because perhaps they won. They won their race. So like they're going to want to basically reassure everyone that the elections were fine. Why? Because they won. And one of the things that I learned from Edward Solomon, he's a genius mathematician, about how these algorithms were deployed in all the different states. The algorithms and the hacking that we're seeing doesn't determine who wins. That's important. It determines who loses. All right. So this is about figuring out and identifying the greatest threats to whatever the cabal wants and being strategic. And if you have enough people that got through the right way, then there's enough legitimacy to the process to say, well, what do you mean? I didn't see this in my county. I didn't see this in my race. And they might be telling the truth. All right. So there's a forensic component to this that we have to kind of get our head around, which is different than what you all are raising, a purely legal question. Okay. These machines weren't certified. If they're not, then we're violating the law. That's a clean theory to proceed upon. But what I'm talking about now really ties into the psychology and the human nature component of why people aren't doing what they need to do. Because there's something that's so much deeper and pernicious that's under the surface that we have to diagnose. Because the legal question, I think, is clear. It's easy. What you all are asking me is, can we win there? And I don't think we can solve the legal question because we've got a morality issue. We have a corruption issue within the system. So it's hard to say who the bad actors are, who's complicit intentionally or through ignorance, some willful ignorance. But that's the problem. That's probably the best job I can do in answering that question.
I'll just add that in the pleadings, we're not going to point fingers at anyone. It's going to be as cut and dry as possible so that the judges are faced with the clearest, easiest argument that we can present. And then they're just going to have to do their sidewalk and figure out how to get out of it. But then we'll create at least that precedent. And then hopefully at some point, the guilt, I don't know what's going to happen. What's going to wake up 9 Supreme Court justices on the Washington State Supreme Court? They're all bought and paid for by the cabal. So,
yeah, well, I think what will be helpful, and I said this during the Regents University and election integrity conference, was if the domino starts falling over with Maricopa and other places, there are a lot of people that put themselves out there saying there's nothing to see here. Zero fraud. There were judges that wrote opinions that were scathing about how dare you. We've heard from people that said there's zero fraud. When I say let's be placeholders or place markers, that's what we're doing with these lawsuits. Is we're saying you want to go on record? You want to tell us why you think we're crazy? Go ahead. Let's get it in black and white. Let's let the ink dry. And if we can expose the corruption, if anything, we're going to show some judges, we're going to highlight and confirm which judges were following their oaths, following the law, and which judges we need to get rid of. And what's really cool about this is that a lot of judges aren't elected. If you're a state judge, depending on your constitution, you'll usually have an appointment. Usually there's one term where you'll have to go through an election. And after that, if you survive, you have what are known as retention elections, where it's basically a voter confidence ballot initiative. And if the voter confidence is high enough, the judge gets to stay there at the state level. Federal appointments are different, right? You get your lifetime appointments. But what's really cool about this is if this comes back and bites these judges in, as my wife would call them, the tookuses, then when a retention election comes about and we're talking about whether someone is fit for office, talk about the press releases, talk about the mailers, talk about all the things that we can get out there to alert the public on how they failed to meet their obligations. And so this is kind of a nice political landmine that we can set where we have to start thinking strategically in maybe the victory isn't going to be enjoyed in the courtroom. It could be done politically. So let's give them enough rope to hang themselves. Let's give them the 2x4s to build the gallows and see what happens. But with
Love it.
that,
That's great.
I'm going to go ahead and close the roundtable on Quo Warranto. I'll post this little roundtable as soon as I can out there, and I'll invite our audience, if there's things that we didn't discuss, or perhaps you have insights into the law that we don't, send me some messages at theprofessorsrecord.com. I'll put you in touch with these lovely people, and we can always do another roundtable. All right. With that, I'm going to go ahead and end our session.
Thank you.
Thank you.
Thank you.
Thank you.